doesn't do its job. Chair, this is a very big challenge. How can we approve money to pay UMEME when you know that UMEME also owes a transmission company within government? Like you stated, I just want to make this clear with boldness that it is completely unacceptable. What we have to proceed on this matter, Chair, is that these people were paid. Let them pay transmission their money. If they fail, there is nothing like a London court. UMEME is just here with us locally. When did they become an international company? Because as far as I know, for you to go to a London court, you must be an international company. Are we now saying that UMEME has suddenly changed to become international? You having shareholders who are international does not make it international. We operated with these people in the local space here. Honorable Minister, this is completely unacceptable. UMEME was paid. Let them pay. And if there are any other arguments or maybe what you could call outstandings that they are demanding between government, because you see also tomorrow we are now going to have problems with the ETCL. They are going to tell you we are not performing because of this date. Now they may not be able to pay generation. Generation comes and says, but now we can't generate. Transmission has not paid us. I even know private people who are loading power to the national grid. It means that there are going to be problems. I think as a committee, let's take this very seriously, Chair. And good enough, the PS is here, the minister is here. Let the minister take this. Who are these directors of UMEME? They are here. Let them come and give us the money, pay transmission, so that there's effective service delivery. I beg to submit. Otherwise, I also want to join the others that after the meeting, I also want to go with one person from here. I'm not going to leave them.
That to say that UMEME says they are not going to pay what is due to UETCL because they dispute the amount paid to them as a buyout, and therefore the London Court of Arbitration to resolve that first. It comes back to indict us. Why didn't we also behave like the way they have behaved? That we will only give you this if you have, because we could have also chosen to say, prior to you receiving the buyout amount, clear the obligations that are due to the, particularly your service provider who provided you with power, which is transmission. Why is it that at this stage is when it must be subject to the decision of the London Court of Arbitration? Our biggest concern is like the way Honorable Eku is raising, that there are local suppliers or there are local people who generated and supplied. There is also our own UGcl, which we must definitely work very hard to ensure that it is at its best. Remember, Minister, when we were doing rationalization, there was this other idea that government had floated a little bit, that probably we might eventually consolidate our generation, our transmission, and our distribution. We don't want UGcl to come when they are weak. We don't want transmission to join UGcl when they are weak. So one way or the other, all our companies must also receive what is due to them. So I appreciate what Honorable Eku is saying. The minister wants to respond, but I see the gentleman who had...
This is a matter that we were fully aware of in terms of UMEME's what they owed to UETCL at the time of exit of this concession at the end of March of this year. And we did issue a number of notifications to UMEME, and we were cognizant of the regime under which we were operating. Like the minister already highlighted, we had a lease and assignment agreement with UMEME as the Ministry of Finance and therefore government that had clear conditions on how we treat issues of the assets and the buyout amount. And UETCL also had a specific agreement with UMEME in terms of power sales that equally had its conditions. Now, mixing the two regimes because we had a contested amount in terms of the bill was not tenable legally. But critically also, I know Chairman had indicated a strategy, why didn't we do exactly the same of holding back until UMEME paid UETCL? That was not going to be practical because payment of the buyout amount was a condition for asset transfer. So if we hadn't paid and on time, then UMEME would not have relinquished the assets for us to commence the operations. So at that juncture, you don't want to be in that contestation. You're working on keeping the lights on. That was very critical. So it was a conditionality, and it was important that we clear the buyout amount for purposes of inheriting the assets. And then under the two regimes, we proceed on issues of contested amounts.
A little bit of confusion is, now, we needed to clear the buyout amount so that we can be able to take possession of the asset, okay? But this person whom we needed to pay the buyout amount is also a debtor to us, okay? Now, of course, it is okay for us to pay the buyout amount. My question now is, would you have rather gone to a state where, because the money that UETCL is owed is close to just about 500 billion, correct?
The total is about 600.
600.
Yes.
And what was the total amount of buyout that we eventually paid, for instance?
We paid out 180 million US dollars.
Which is also about 700 billion. So in other words, we almost were owed about 90% of what we were paying to this person. Now, number two, as we are in the London Court of Arbitration, are we arguing there in the arbitration court? Are we arguing as solely government of Uganda, which is also representing the interests of UETCL, or was it that UETCL should have also filed a counter claim since it is a limited liability company which has a corporate personality and can sue or be sued? Or do we assume that whatever issues that Uganda and UMEME are trying to resolve in London, those also include the interests of UETCL? Is that correct?
Earlier, these two contested amounts, the buyout amount and the outstanding payment to UETCL, are governed by two separate regimes. UMEME, of course, wanted to have them enjoined, and we handle them together. And the Attorney General guided that these are two different matters. And indeed, we are proceeding for arbitration on those issues separated. They are not conjoined.
Now, my issue is there at the London Court of Arbitration. Now there, UETCL, supposedly, who is at the background, I want to assume they are being represented by the Ugandan Attorney General. And if the Attorney General's guidance was that there were two separate legal instruments managing the two claims, in UMEME's, you might guide me if I'm wrong, if it is UMEME that has run to the London Court of Arbitration, theirs is in as far as the claim of underpayment is concerned. Is it also true that on behalf of UETCL, we have also filed another matter using a separate instrument in which we are proceeding on UMEME to pay us what is due to ETCL. Is that correct?
Make a claim to UMEME that they didn't honor, and under the existing agreement they have with UMEME, how to proceed and raise a dispute in alignment with the terms of the agreement. So it is UETCL that is taking UMEME for this dispute resolution, working with the Attorney General, of course.
UETCL, are you here?
He's here.
You're here. Have you, as it is already, and I see the corporation secretary, company secretary is there, do you already have documents, for instance, that this committee can also, you know, we are not, whereas we have lawyers, we are not lawyers, but yes, we can read. Do you have documents that attest that as a company owned by Ugandans, so to say, through our government, you have gone ahead to file a matter before this London Court of Arbitration?
Yes, Chair. The London Court of Arbitration.
Something?
And then and also I wanted to find out why not here in Uganda.
No, just hold on a moment. Okay, her questions will be answered, but let's have you.
Chairman, the inquiry is, are both agreements subjected to the London Court? Or is only one and both?
Okay. You were listening in a scary way, but go ahead, please.
I was listening, but also I'm happy that the PS has tried to make it clear. But there's a big problem. A very big problem. You know, by the chair, this London Court of Arbitration, first and foremost, it is for wasting time. After how long? It will drag until one party loses interest, or maybe by then may even not even have anybody to defend them. That is the first scenario. Second case scenario is that UETCL, when they were going into agreement with UMEME, at least I know with government MDAs, they automatically, that clause is a silent clause always of arbitration. I don't know, really. I think the lawyers need to first maybe, you know, a little bit explain. Because for me, I have seen it. It is a very silent, it never, even in the agreements, it is just silent until when eventuality of a situation comes and they tell you, no, we can't negotiate in Uganda. But the point I'm coming further for is that, but if UMEME, UETCL supplied UMEME with the power and issued invoices, why would I go to the London court? If it is to the London court, it's to negotiate the payout that you are discussing. Dispute, maybe you are saying I could be having more assets, I could have done this. And what I know, Chair, UMEME and the ministry, for example, there were audits yearly. I think there were audits yearly, in far as yes. So if we are talking of a dispute, you are disputing the final year of takeover. When you are contract, I do not need you. So it means that the power that was supplied to UETCL or to UMEME, yes, final year, what happened?
Honorable Chair.
I really want to know, at this point, who is representing UMEME in these discussions? Is there anybody who represents UMEME in this our discussion? Is there an opportunity for UMEME to be here to speak for themselves? Because by the time the matter goes for arbitration, that means UMEME is objecting to the figures. UMEME is refusing to honor what they should ordinarily do without arbitration. So what is the problem? If I didn't get the picture well, may I be put in line, Madam PS? I thank you.
So as I prepare to invite the team, number one, UMEME remains a going concern. So the committee you can invite them in their own right. They remain a going concern, and we are having this discussion. Two, we have clarified that we do have agreements that we are abiding by in executing this dispute with UMEME, entered into 20 years ago. Number three, UETCL raised a claim with UMEME, and the MD is going to speak to this, and UMEME insisted on handling this alongside the buyout settlement, and we said those were separate regimes. I'm going to invite the MD UETCL and then ERA to just speak to the claims that you raised with UMEME and then the process we undertook in engaging them.
Thank you, Chair and honorable members. First, one thing to note is this whole disagreement between UTC and UMEME is in a way unique because UMEME does not dispute the figure, the invoice. However, they are insisting, like the PS has brought it out clearly, to handle our issue with the buyout issue. They are saying they are not drawing a line between government and UTCL. And I think this is now what is taking us to the Court of Arbitration in London. We insist our issue should be separate from the buyout. We have an agreement between ourselves. You should go ahead and honor. They are saying they will not draw a line. They want both handled together. That's what I want to clarify. Thank you.
Okay, CEO, you can just comment on the arguments.
Thank you, PS. Honorable Chair and members, 100% a government company. UMEME in all its covenants, they look at government as the obligated party beyond UETCL. So while UETCL has initiated all the claim, issued the invoices in line with the power purchase agreement, UMEME is not disputing the amount. They've jumped UETCL and called upon their clauses in the agreements, concession agreement, implementation agreement, and now the matter is being handled by the Attorney General representing the government. As we speak now, it is the Attorney General on both issues, the disputed buyout amount, as well as the failure of UMEME to pay in a timely manner on amounts that are not disputed by them under the PPA. Both items are now handled by the Attorney General. Thank you.
This is quite interesting, colleagues. Extremely interesting. If in the mind of UMEME, UETCL and government, why didn't they use the concession agreement as the basis of power purchase from UETCL? Why did they have to sign a separate agreement? Signing of the separate agreement with UETCL presupposes that there was a corporate body called UETCL that owned the right to supply and therefore bill for the what? For the power. So it's just a flimsy excuse to say, you see, because government owns it 100%, a corporate entity is dealt with legally in its own right. It's no excuse. Number two, which is also, of course, something that partially we want to bring back to you, and particularly Engineer Ziria and ERA. How did we get to a point where the total amount of power supplied to UMEME, for which they profiteered and earned revenue, was almost equivalent to the amount that was due to them by way of buyout? It means that you cannot, because if after 20 years, as a result of a breakdown in relationship, we are to pay them approximately 700 billion. How is it that the total amount also our company is owed by them is 600? It means that it is something also accumulated over time. Who was there or who was supposed to ensure that before we allow for UMEME to be able to make other investments, report that they are actually either profitable or making losses, that they first settle their balance sheet? Because it means that every other time UMEME did financial year reports on their balance sheet, they should have posted that they owe so much amount of money, and therefore it should have already raised the red flag. But number 3 from our side, if up to this stage there is the matter of power supplied, somebody does not dispute the invoices, but they are bringing a matter of buyout, why haven't we filed a civil suit in the commercial court to deal with the business transaction? Because when we go for arbitration, arbitration presupposes that there is going to be a way in which we get a win-win balance situation. But the other side, we know that this relationship has already broken down. That's why we are dealing with alimony. The buyout is alimony. What you give somebody as they depart the marriage. So we cannot say we are in arbitration. What do you arbitrate? Do we still think that we can be reconciled? No. It is a point at which we cut our losses. So under the current circumstances, I like the fact that the PS has told us that UMEME still remains a going concern in the country. Therefore, either UMEME in itself or its directors or its assignees are still liable to the whims of the law in the country. Why haven't we proceeded in the direction of commercial litigation on the basis of a financial transaction? For me, that is what I would like us to properly delve into. CEO, sir.
So, like the PS says, we are the ones who went to London court, okay? So there are 2 disputes in the London Court of Arbitration. There is the UTCL sued UMEME, then UMEME sued the government of Uganda. So there are 2 separate disputes in London Court of Arbitration. But why did we go to London? The agreement said any amount up above $7 million, you go to London Court of Arbitration. So it ruled, it locked out the civil jurisdiction here in Uganda. So according to the PSA, any amount outstanding in dispute above $7 million, the jurisdiction is London Court of Arbitration, and that is why we're there.
Before you, Honorable Angura.
Okay. It was a demand ranging back to what time?
Oh, you are saying in which we accumulated
that
the invoices amounting to 600.
Yes.
That's what you're trying to say.
Yes.
For instance, what are the intermediate invoices
Absolutely.
over a period of time?
Yes, over a period of time.
Okay.
And why were they not being what?
Simple as it is. UMEME did not dispute the figure that UETCL is demanding for supply of power. Why did you go to the Court of Arbitration? To do what? I am here because to arbitrate, it means we are not agreeing. Then invoke, we have laws, we have the Constitution. We have laws here in Uganda. It means that whatever UETCL is doing in the Arbitration Court of London, Nobody knows, because it should be government of Uganda where they have said that no, you are paying us a little money for our investment over 20 years. That one is clear that there's a dispute on balancing figures. But here, they have said you demand us 600, yes. So it means that, Chair, as we proceed, there's something wrong. There is something wrong.
Okay, I know the CEO is coming in, but my understanding also is that somebody chose to do financial engineering at the expense. For all this time, UMEME was supposedly making profits in which they kept paying out dividend on their shareholders and to themselves. And indeed, most of the people that work for UMEME were earning way beyond the imaginable salaries this country could ever pay. You know, it is common knowledge in some of the social media publications that the CEO of UMEME probably earned close to about 150 million. But you see, at the end of the day, what was happening, that whereas they were receiving the power that belonged to Ugandans, supplied by a Ugandan company, all they chose was to sit back, use our resources and not pay for them, while aware that at the end of the day, they will hold Uganda at ransom and want to trade off. That's what they are trying to do. They would like, that is why they chose that the matter should end up at the at London Court of Arbitration, so that they can trade off this amount that is due to them by way of buyout against the electricity, the energy that they had been doing business on over a period of time. Indeed, colleagues, we need to expand this conversation.
Of $7 million to London Court of Arbitration. And UTCL was supplying UMEME, but they could not follow up the invoices supplied, they could not follow the payments, and somebody allowed the payments to accumulate, aware that the concession period of UMEME was coming to an end, but somebody slept on job or deliberately allowed this situation. Now, as it is, UMEME now says, I agree with the figures, but he refuses to pay, so that the whole matter does not get resolved here. It has to be escalated to another place for... I think there's something we need to deal with. But luckily, the PS said the entity called UMEME is reachable. Can we have that entity here together with the ministry so that we can probe this matter more effectively and efficiently? As it is now, the questions which should have been answered in the presence of UMEME, UTCL is going to attempt to answer them without UMEME. The questions UMEME should have answered in the presence of these beautiful people cannot be presented. In my view, Honorable Chair, we need another meeting where we have the entity called UMEME represented fully, legally, so that we can have a better discussion. Because there's something more than what is being discussed here now.
Thank you, Honorable Feta. That is, I see that is a very much close to the direction we should be going, because it's just not enough. Go to another party. We keep quiet. 600 billion is approximately 160 million, thereabout, isn't it? So as we kept on going from 7 to 14 to 21 to 28 to 35, and somebody knows that eventually this money will be subject to a process out of even the jurisdiction of the Ugandan law, somebody should have woken up and said, there is something going wrong here. Chigorobia.
Thank you, Chair. I just want to seek for your guidance, because here we are with the ministry as government. Do you think if we bring UMEME, since the issue is before court, do you think they will be at ease to discuss it?
There is nothing like sub judice in this case. First and foremost, the International Court of Arbitration is not a court of strict evidence. It is about looking at a balance of probabilities. Who could have, who couldn't have adhered to the provisions of an agreement. It's not a matter of, strict investigation. Go, who did what in confidence and the like. So what is before the Court of Arbitration is not a subject, because the presupposition of sub judice is that you are likely to influence the decision of the court before which a matter is. In this case, the arbitration court is not seeking to say so-and-so is right and so-and-so is wrong. It's largely going to say, how do you invoke the provisions? But two, it's outside the jurisdiction here. If the matter was before a Ugandan court of law, yes, then the sub judice rule would apply. Honorable Minister. Oh, okay. So, colleagues, I believe that tentatively this is how we should proceed. That based on the guidance of the Deputy Chair, we would say that we need possibly another opportunity of interface when UMEME is also here. Ours is an oversight activity. As a committee responsible for the sector, may I have the Honorable Nakaziba with me and the other colleagues so that I am with all of you. We believe that having both sides of this matter would be very crucial. So what we will do, we will consult with the minister and agree when at the earliest opportunity we convene here in another meeting where representatives of UMEME are, because I believe that UMEME is still, as is, subject to all the provisions of the Ugandan law, because it's still a company registered and domiciled in Uganda. And two, where resources have been drawn and have recourse to public funds in Uganda, Parliament, in as much as it is able to proceed and investigate and find out what could have gone wrong. So for now, let us put a comma on this specific one, ask our team to highlight a brief report to the committee as we prepare, possibly next week, to have another interface where we invite UMEME to join in. So, but at this juncture, I would like to request the Minister to make additional comments on the other issues raised by the